Good afternoon. I'm Andy Lenahan, president of the club. Welcome to City Club and to today's discussion on the balance between national security and civil rights. Joining us today are Assistant U.S. Attorney Charles F. Gorder, Jr. and Charlie Hinkle, an attorney with Stoel Rives. Before we begin our program, I have the usual few items of City Club business. First, due to unavoidable changes in Governor Kulongoski's schedule, he has had to reschedule the State of the State address at City Club. The governor's speech had been scheduled for February 13th. He'll now deliver the State of the State presentation on Friday, March 5th. Appropriately enough, we're going to do it at the Governor Hotel. Members only can still pre-register before ticket sales are open to the public on February 26th. If you've already pre-registered, don't worry, your registration will be carried over to the new date, but we do encourage you to prepay your tickets. That'll avoid having to go through the lines on the day of the event. So you can check in your bulletin or visit the website for further details about how to register for that program. Next Friday, February 6th, City Club and the Portland Schools Foundation welcome Wendy Purifoy, a nationally recognized expert on school reform and civil society and president of the Public Education Network. She'll talk about the No Child Left Behind statute and the condition of public education. That program will also be at the Governor Hotel, and you can reserve either online or by calling the club. City Club's book and discussion group, Citizens Read, met last Monday night to discuss David Peterson Del Mar's book, Oregon's Promise. Next month, or that is in February, the group takes on Better Together by Robert Putnam, who, as you may know, authored the acclaimed book on the decline of civic engagement, Bowling Alone. The book group will meet on Monday, February 23rd at the Zimmerman Community Center in the Pearl District to chat about the book. And then on February 27th, Robert Putnam will be our Friday forum speaker. Copies of Better Together are available for purchase today in the lobby. We encourage all of you to read Better Together, whether or not you can attend the book club, and discuss it with your colleagues. And we look forward also to seeing you here on the 27th. Today I'm happy to introduce the City Club Research Board's Community Scan, which is an effort to gather suggestions for future study and program topics from City Club members and the community in general. If you've ever said to yourself, this is what City Club really ought to be looking at, or this topic would make a great Friday forum, well, this is your chance to provide input. To get you started, you'll find there should be cards on each of your tables that gives you instructions about how to submit ideas, or you can read the write-up about the community scan in the current bulletin. I'd like to welcome members of Lincoln High School's Constitution team and thank their sponsor, Stoel Rives. Today's discussion is particularly appropriate given your group's focus. If you're not a member of City Club, now is the perfect time to join. You heard today about the new book group and you know about the Friday forums, but City Club has many other activities going on, such as our research, our issue committees, and our new Leaders Council. It all starts with becoming a member. This is a particularly good time to join because members have the opportunity to pre-register for Governor Kulongoski's State of the State address on March 5th. Again, City Club members only can pre-register before March 27th. After that, there's a very good possibility that the program will sell out. So you can become a member today by talking to staff or picking up one of the brochures, membership brochures, which are here at the back table. Broadcast of City Club programs this quarter is made possible in part by corporate underwriting from Pacificor, CH2M Hill, and Schwab Williamson and Wyatt. We're very grateful for their support. So on to our program. Although Portland is a continent away from lower Manhattan, the terrorism of 9/11 has reverberated particularly strongly here in Portland. The cases of Mike Hawash and the Portland 7 have only increased our confusion about the degree of the threat from terrorism and the appropriate balance of civil rights and national security. With us today are two attorneys who are particularly well suited to discuss this balance. Our first speaker, Charles Gorder, has been an assistant United States attorney engaged in federal criminal prosecution in Oregon and California for over 23 years. In September 2001, he was appointed to be the coordinator in Oregon of the United States Justice Department's Anti-Terrorism Advisory Council, which was created by Attorney General Ashcroft in response to the 9/11 terrorism. He is also an adjunct professor of law at Northwestern School of Law at Lewis and Clark College in Portland. Mr. Gorder received his JD degree from the University of California at Berkeley, that is Bolt Hall, in 1976, where he was managing editor of the California Law Review. In 1973, he received a BA in economics with highest honors from the University of California at Riverside. Mr. Gorder prosecuted the terrorism case involving the so-called Portland 7 in federal court here in Portland. For our second speaker, I'm pleased to welcome back one of our own, Charlie Hinkle. Charlie is a former president of the City Club of Portland, who in 1996 received the City Club Award for his contributions to the club and to the community. He's a partner at Stoel Rives law firm and an ordained minister in the United Church of Christ. He taught constitutional law courses at Lewis and Clark Law School for many years, and he's a former president of the ACLU of Oregon, as well as a former member of the National ACLU Board. As attorney for the Oregonian and for the ACLU, he has been lead counsel in many cases involving free speech and other constitutional law issues, including the death penalty, assisted suicide, obscenity, freedom of association, and religious liberty. Charlie Hinkle is a graduate of Stanford University, Union Theological Seminary, and Yale Law School. First, we'll have Mr. Gorder.
Well, thank you, Andy. I appreciate the opportunity to be here today and speak to the City Club. I've admired your work over the years in discussing local, state, national, and I guess sometimes even world issues. I didn't realize that Charlie Hinkle was a member of the club, so I guess he's got the home court advantage today. But he was gracious enough to allow me to go first. I'd like to talk about what I view as the core function of government in a democratic society, and that is protecting us as citizens from our enemies abroad and criminals at home, and at the same time protecting our liberty. And that's a particularly important topic during times of war. Sometimes I have the feeling that those of us who are blessed enough to live here in Oregon forget about the fact that it is a war that we're fighting. And I'm reminded that I have a friend who lives here in Portland. He grew up in Long Island in New York. And shortly after 9/11, it was probably either Thanksgiving or Christmas, he went home to Long Island to visit family and friends. And he did what people normally do in that situation, went to see some of his old high school friends, relatives, and that sort of thing. When he returned, he told me, "Charles, I didn't talk to a single person who didn't know someone who died in the World Trade Center. Not a one." So that was the Long Island story. Let me try to bring it a little closer to home to those of us in Oregon. In August of 1998, our embassies in Africa were bombed by Al-Qaeda in Kenya and Tanzania. 225 people were killed, and about 4,600 were injured. 2 weeks later, a message was read from the pulpit in Karachi, Pakistan, that said the following: "Spoil their trade, burn their companies, drown their boats, and target their planes, and kill them on the land, in the oceans, and in the air. From your brother in American prison, Omar Abdul Rahman." Now, who is Sheikh Mohammed Omar Abdul Rahman? Well, some people call him the blind sheikh. He was the spiritual advisor of the people who attacked the World Trade Center the first time around. And he was, at the time this message was read, in prison, having been convicted in a subsequent plot to blow up landmarks in New York City, like the Lincoln Tunnel and the UN. What most of you probably don't know is that the blind sheikh was here in Oregon shortly before his arrest, visited Corvallis. Now, I don't know why he was here, but I suggest he was not on a peace mission. What I'd like to specifically talk about today is our war against terrorism and the Patriot Act. Because frankly, every day I see misinformation and misleading stuff in the general media, particularly the print media, about the Patriot Act. I graduated from law school in 1976, so I've really been a student of the law since I started in 1973. I have never seen a legal issue so poorly covered in the media as the Patriot Act. And I hope that you feel as leaders here in Oregon that you should do a better job. Let me talk a little bit about what the Patriot Act does not do. It does not suspend the Constitution or the constitutional rights of Americans as determined by our courts, and in fact it could not do so. Congress cannot pass a law suspending the Constitution. It does not authorize the detention of material witnesses. Although the Federal Criminal Code has done so for over 40 years, but only under the supervision of a federal judge and with the witness having a right to counsel. It does not authorize the President to detain persons as enemy combatants. That's an issue that our Supreme Court is going to be visiting sometime this spring, and we'll have the latest word on what the Constitution says in that regard, I assume by the end of June. The issues right now in that area really involve what is the President's inherent power in time of war to deal with enemy combatants. But the Patriot Act has nothing to say about it. It doesn't authorize military tribunals of either foreigners or United States citizens who are captured fighting for a foreign enemy. Although, according to the Supreme Court, the Constitution does, and the President has authorized those tribunals for foreigners, but not U.S. citizens. The Patriot Act does not authorize prison officials to abuse Muslim prisoners, despite what you may have read in one of the most ridiculous editorials I have seen in the Oregonian in a long time. I almost feel incumbent to say, because the Patriot Act seems to be blamed for so much of what people don't like these days, that it doesn't authorize high unemployment in Oregon, federal tax cuts or Measure 30, clear cutting or prayer in the schools. So what does it do? Well, I work with the Patriot Act every day, and it has really two important functions from a practical standpoint, day to day. Let me just briefly describe them. Before the Patriot Act was passed, we had a patchwork of criminal investigative procedures that had been developed over time in the 20th century to deal with the way people communicated in the 20th century. Snail mail, landline telephones, and personal meetings. But as we approached the 21st century, people began to communicate with cell phones and fax machines and email and pagers and voicemail and satellite phones and the internet. And what the Patriot Act has done has tried to take those forms of communication and update our criminal investigative procedures so that we can do things efficiently while still protecting our constitutional rights. Let me give you one example. Before the Patriot Act was passed, if I wanted, as a prosecutor, to get a hold of someone's email, I had to get a search warrant. To get a search warrant under the Constitution, I've got to be able to show probable cause that evidence of a crime has been committed, and that evidence of that crime would most likely be found in a person's email. You would take that to a judge, and if the judge agreed, he would issue the search warrant. It's the same rule under the Patriot Act, but here's the difference. Traditionally, a search warrant is issued by the judge in the place where the property to be searched is located. Well, let me ask you this. When someone in Portland, Oregon emails somebody in Eugene, and the email goes through AOL, which happens to be located in Northern Virginia, where is the email? That was the problem before the Patriot Act. The email was in Northern Virginia. And so Northern Virginia, where AOL is, and the San Francisco Bay Area, where Hotmail and MSN are, and Yahoo, there were long lines outside the magistrate's offices of people from all over the country coming to get search warrants for email. Now, they had to show probable cause, but we were faced with a dilemma here in Portland. Do we fly an agent to Virginia to go see the magistrate so there's somebody there that knows about the case if the magistrate has some questions? Or do we send some agent in Virginia that really doesn't know anything about the case? The Patriot Act changes that. Now, I can go see a judge in Portland, Oregon, if the crime being investigated occurred in the District of Oregon. But the same standards to protect our civil liberties are there. Probable cause has to be shown before the government can get email. So that's one example. The second example, from a practical standpoint, of how the Patriot Act really works is it tore down a wall that had been created between our intelligence community and our criminal investigation committee. Before the Patriot Act, there were literally two FBIs. There was the FBI that I worked with, which investigated crimes, and there was the FBI that tried to investigate international terrorism. Now, if you're committing international terrorism in the United States, you're most likely committing a crime also. So you could have two FBI agents who were investigating the same international terrorist suspect in Portland, Oregon, for example, but because of this wall, they couldn't talk to each other. They were not allowed to share the information that they had learned. Now, there's been a lot of talk about connecting the dots. Well, it's pretty hard to connect the dots if you don't have access to the other guy's dots. And that is what the Patriot Act has tried to do, tear down that wall and allow us to communicate between the intelligence side of the FBI and the criminal investigation side of the FBI. It was a terribly inefficient system, and we can't afford it in a time of war. How am I doing time-wise? Okay. Let me just talk about a few other issues. I know some of you out there are thinking, okay, Mr. Prosecutor, what about these library searches? Because that's something that I read about a lot in the newspaper. You've heard the story about how under the Patriot Act, the FBI can sneak into the Multnomah County Library and grab one of the employees and say, give me the records of John Doe, and if you tell anyone, we're going to ship you off to Guantanamo Bay. I'm here to tell you that that's an urban library legend. You know, when the press first called me about this thing, you know, I didn't know what they were talking about. Now, I happen to have a computer version of the Patriot Act. It's about 100 pages long. And I did a word search for library. Nothing there. Libraries. Didn't see it. Then I started scratching my head, and I said to myself, well, why would they have to change the rules about libraries? I've always been able to subpoena library records. If they were relevant to a crime, I could get a grand jury subpoena and subpoena library records. But then I finally realized what they were talking about. You know those guys on the other side of the wall, the ones who were investigating the international terrorists for intelligence purposes? They couldn't issue subpoenas for library records. Now, the Patriot Act allows for a procedure where the FBI can go to court and get a library record if they think it's relevant to an international terrorism investigation or an espionage investigation. But give us the benefit of the doubt to have a little common sense. I've had that power now for 24 years through grand jury subpoenas. Do you know how many library records I've ever subpoenaed? 0. Because normally it's just not relevant to what we're trying to do, which is to prove people are committing crimes. Now, I read in the paper recently that somebody was arrested for raping a girl who he met using a Multnomah County Library computer on the internet. We don't do regular rape cases in federal court, so that's not a case I'd be involved in. But if I was prosecuting that case, you bet I'd want the record from the library computer that showed that this guy was in communication of the rape victim to prove that, that he did it. So there are occasions where a library record might be relevant to a criminal case. The Patriot Act provided for congressional oversight of this and a number of other areas of the Patriot Act. And so these court orders for records have been supplied to Congress for, since the Patriot Act was enacted. They never indicated there were any problem, and the Attorney General has recently, because of all the hullabaloo, declassified the subject and informed us that there have been 0 library or bookstore subpoenas or court orders issued under this provision of the Patriot Act. So I think it's kind of an issue that's been overblown as part of this rhetoric that is really beyond the pale. We in the Justice Department welcome the occasional tension between liberty and security and the debate that goes on about that. The wisdom of the changes that have been made in the Patriot Act. But we would like that debate to be reasoned. We all believe that we will ultimately prevail in this struggle because of our government and our citizens' commitment to allow all of us to live in freedom and with individual liberty. So I hope as you participate in that debate yourself, you can appreciate a bit more how the Patriot Act simply updates criminal investigation procedures to the 21st century. It allows us to keep up with the Joneses, or should I say the Bin Ladens. You should also know that this war probably is not going to end soon, and we're going to have to be continuing to balance our liberty and our security every day. And we're hiring. Now, I'm not speaking now just from the Justice Department standpoint, but I think I can speak for the Department of Homeland Security, our intelligence community, and even the military. If you know some bright young adults who are willing to work hard for low pay and want to work to save the nation and make it a nation worth saving, tell them to give us a call. Before I sit down, let me tell you, I've tried to do a lot of reading in the area of terrorism since I started this project a couple of years ago. So I have no pride in authorship because someone else wrote this, but this is the best I've heard in that period of time. It's from Ernest Lefevre, who's a fellow at the Ethics and Public Policy Center in Washington, D.C. Today's terrorism, excuse me, is not a new phenomenon. The Vandals who sacked Rome in 455 AD were terrorists who had no respect for the literature, culture, or morals of civilized society, and little compassion for their citizens. In our time, both Hitler and Stalin were terrorists on as grand a scale. What has changed is the technology of terror. The Bin Ladens of the world have at their disposal instant communication, sophisticated weapons, and international bank accounts. But then, so do we. Most important, we are armed with the weapons of truth and freedom. Thanks.
How to strike the balance between liberty and security is a perennial question in a democracy. And Charles Gorder and I agree on one point at least, that is a question how to strike that balance, a question that has become increasingly urgent since 9/11. 45 days after 9/11, Congress passed, with no hearings, with virtually no floor debate, the USA Patriot Act. That act runs to several pages, as Charles says, several hundred pages. There are many provisions in the act that raise civil liberties concerns. I will mention just 4 of them. First, the Act requires a judge to issue an order requiring disclosure of virtually any kind of information about a person, according to Attorney General Ashcroft, even private genetic information, whenever a law enforcement officer certifies that the information may be relevant to a national security investigation. The Act allows the government to find out what books you've checked out of the public library. Yes, it does. Or purchased from a bookstore. Yes, it does. Based solely on the FBI's assurance that the information is relevant to an investigation, without any showing of probable cause under this section of the law, without any independent review by a judge, without notice to the person whose information is being sought. A library or bookstore or college or hospital that receives an order to disclose this kind of information is forbidden by the terms of the order to reveal its existence to anyone. The American Library Association calls this provision of the law a present danger to the constitutional rights and privacy rights of library users, and it has called on Congress to repeal or limit it. Two very conservative Republican members of Congress from Idaho, these are not liberals from San Francisco, Senator Craig and Congressman Otter have introduced legislation in Congress that would do just that, because they are concerned that this provision of the Act has gone too far. Secondly, the Act greatly expands the use of roving wiretaps. A wiretap order directed to a person is no longer confined to a particular computer or telephone. Instead, it may rove wherever the target goes, which may include library computers. And this section of the law is not limited to terrorism cases. It applies to any federal crime, bank robbery, drug cases, killing a bald eagle. It allows the FBI to take their requests, as Charles said, for search authorization to judges anywhere in the nation. Until the Patriot Act, if an FBI agent in Oregon wanted to obtain a search warrant directed to a person in Oregon, the agent had to present his or her reasons to a judge in Oregon. Traditionally, we have believed in our society that local control and the exercise of law enforcement power by judges and police in our own communities was an important protection for individual liberty, but not anymore. Under the Patriot Act, the FBI can obtain a search warrant from a judge in Portland, Maine, to search a computer in Portland, Oregon. So the Bush administration was able to use the emergency atmosphere created by 9/11 to make a fundamental change in law enforcement procedures having nothing to do with terrorism. Third, the sneak and peek provisions of the Act allow the FBI to search a person's home or office without telling the person until days or weeks later. The FBI can obtain authority to engage in these searches merely by telling a judge that the investigation of any federal crime, and again, not just terrorism cases, any federal crime, the investigation might be jeopardized unless the FBI is permitted to conduct these searches without notice. Again, the person spied on does not have to be the target of the investigation, and the government is not obligated to report back to the court or to the person spied upon until days, weeks, months after the event. Fourth, the Act authorizes detention of U.S. citizens for 7 days without any judicial review, and it allows non-citizens to be detained indefinitely without any meaningful judicial review. 2 months after 9/11, the government said that it had detained 1,182 persons under this provision of the Patriot Act. It has not released any numbers since then. So we don't know the number of people who have been detained under this section. We don't know how many have been released. We don't know where they were held. We don't know what charges, if any, were leveled against them. We don't know if they were allowed to see lawyers or have visits from their family members. With one exception, we don't know their names. We know none of these things because the government has never released any of this information. The one exception to the wall of secrecy surrounding these detainees resulted from a mistake made by a federal court clerk down in Miami who inadvertently listed the name of one of these detainees on a public docket sheet for a few hours before the mistake was discovered and the name was removed. Mohamed Belahuel was the name on that docket. He is an Algerian-born waiter who was detained in secret after 9/11. He was eventually charged with violating his student visa. That's his only crime. He challenged his secret detention in federal court in Miami. He lost. He appealed to the Court of Appeals in Atlanta, where he lost again. And except for that one inadvertent disclosure on the docket list down in Miami, there was no public record that his case ever existed. Every hearing was held behind closed doors. Every document was filed under seal. Now he's appealed to the Supreme Court, and the Bush administration has asked that court to keep its hands off. Don't get involved. But as a result of this case, we now know that the federal court in Miami, and perhaps in other federal districts as well, is maintaining a whole separate docket of non-public cases whose very existence is being kept secret from the public. The Reporters Committee for Freedom of the Press has called the Bella Joel case perhaps the most egregious recent example of an alarming trend towards excessive secrecy in federal courts, particularly in cases that bear even a tangential connection to the events of 9/11. A free and open society cannot tolerate hiding federal court proceedings from public view. Well, these are some of the civil liberties concerns that are raised directly by the Patriot Act itself, but they are not alone. They are symptomatic of a larger pattern of action taken by our government since 9/11 that raised the same concerns. Consider the order issued by the Attorney General 6 weeks after 9/11, allowing the government to listen in on conversations between prison inmates and their attorneys if there is a reasonable suspicion that an exchange of information may occur about future acts of terrorism. The president of the American Bar Association said that these new rules seriously impinge on the right to counsel and run squarely afoul of the guarantees of the Bill of Rights. Or consider the several hundred people who are being detained in Guantanamo Bay in Cuba. These people were captured in Afghanistan. They've never been in the United States. They've been held now for over 18 months without charges, without review by any court, military or civilian. The International Red Cross has repeatedly asked our government to give these people the rights that international law gives to prisoners of war, but the Bush administration has refused to do so. A federal court of appeals ruled last year that these detainees have no right to ask the courts to review the legality of their detention because, the court said, the Constitution does not apply to persons who are not U.S. citizens and who are not present on U.S. soil. And that, of course, is why the government keeps these people in Guantanamo Bay instead of bringing them to a military prison in the United States where the Constitution might apply to their cases. 2 months ago, over the strong objection of the Bush administration, the Supreme Court agreed to decide at least the minimal question of whether these persons have the right to have access to the U.S. courts to challenge their detention. But meanwhile, they remain in limbo. Or consider the cases of Jose Padilla and Yasser Hamdi, both American citizens. Both have been designated enemy combatants by the Bush administration. They are being held incommunicado in naval brigs without bail, with no criminal charges brought against them, and with no opportunity to see a lawyer. Padilla has challenged his detention as an enemy combatant on the ground that there has been no declaration of war. And he has also asked the court to require the government to allow him to see a lawyer. The Sixth Amendment to the Constitution says that every person accused of a crime has the right to see a lawyer. But the Bush administration says no. They have opposed Padilla on both of those points. It contends that the Bill of Rights does not apply to enemy combatants, even if they are American citizens, and even though no court, no jury, no judge has ever found that they are an enemy combatant. Last month, the Federal Court of Appeals in New York ruled in Padilla's favor on both points. He has the right to see a lawyer, the court said, and the government cannot detain citizen enemy combatants without specific congressional approval. This time, of course, the Bush administration wants the Supreme Court to get involved, and they have asked that court to reverse the Court of Appeals decision. In contrast to Padilla, who was arrested on American soil in Chicago, Yasser Hamdi, also an American citizen, was arrested during combat operations in Afghanistan. He has been held since the spring of 2002 without bail, with no charges being brought against him, and without a lawyer. A federal trial judge ordered the government to provide information to Hamdi at least regarding the reasons for his detention, but the Court of Appeals not only reversed that order, but went even further to hold that Hamdi essentially has no constitutional rights at all because he was detained during combat operations in a foreign country. When Hamdi appealed to the U.S. Supreme Court, the Bush administration urged the court to stay out of it, but 3 weeks ago the court agreed to hear the case. And several former U.S. prisoners of war who were held as prisoners of war in Vietnam and during World War II have filed a brief with the Supreme Court in support of Hamdi, arguing that the U.S. is holding him in violation of the Geneva Convention on Prisoners of War. The last case that I want to mention is that of Zacarias Moussaoui. He's a citizen of Morocco. He's being held in a prison in Virginia on charges that he was a participant in the planning for the attacks on 9/11. The government is seeking the death penalty. The Sixth Amendment, as I said, guarantees the right to have a lawyer, but it also guarantees an accused person the right to subpoena witnesses in his favor. So Moussaoui's lawyers have invoked that clause to ask the government to be allowed to interview other members of al-Qaeda who are being held by our government, presumably with the hope that they have some information that might tend to exonerate their client. A federal judge has ordered the government to provide access to these witnesses, but the Bush administration has refused. And on October 2nd, the judge issued an order saying that because of the government's violation of Moussaoui's constitutional rights, she will not permit the government to seek the death penalty or to offer any evidence suggesting that he had any involvement in 9/11. It would be unfair, the judge said, to require Moussaoui to defend against such prejudicial accusations while being denied the ability to present testimony from witnesses who could assist him in contradicting those accusations. The government has appealed that order to the Federal Court of Appeals in Virginia, and that's where the matter sits today. Secret courts, secret search warrants, secret detention of hundreds of persons, denial of the right of counsel, infringement of the attorney-client privilege, denial of the right to obtain evidence, restrictions on judicial oversight of law enforcement agencies, denial even of the right to have access to the courts. These all are part of the legacy of 9/11, and we must ask ourselves if this is the kind of America we want. In a fireside chat in 1938, FDR said that the only sure bulwark of continuing liberty is a government strong enough to protect the interests of the people, and a people strong enough and well enough informed to maintain its sovereign control over the government. So our task as citizens, I suggest to you, is to stay informed, to ask questions, to demand accountability, to listen to both sides of the arguments, to be willing to change our minds, and to remember that the whole point of the American experiment was to live in liberty. Thank you.
Well, thanks to our panel. I have no doubt that today's topics will produce a lot of questions. As you know, City Club members have the opportunity to ask questions of our speakers. Our first question today will come from Nikki Lynch, our board member and a 16-year club member, and Nikki Lynch is also a senior financial consultant and vice president at Merrill Lynch. While Nikki's making her question, people should go ahead and line up behind the microphone, and when it comes your turn to ask your question, please identify yourself as a club member, and remember, questions only and 30 seconds only. Thank you.
Well, I feel like I have so many questions. I wrote a lot down and added more during the talk, but I guess the question maybe that rises to the surface maybe is historically, I mean, how does the Patriot Act compare to anything that's happened in the past? And if in the past there have been changes of this nature, were they repealed? Is there a precedent for that?
Well, we've heard two messages from the Bush administration and from the Attorney General. One, the Patriot Act is a minor tinkering with the law, and it doesn't really represent a major change in the law. You heard some of that echoed in what Mr. Gorder said this afternoon. But on the other hand, they're very clear, they're very sure that they need the Patriot Act, and they want to renew it, and not only that, they want to push Congress to pass Patriot Act 2. There have been, in times of grave emergency in the past in our country, civil liberties violations. After World War I, the Palmer raids on homes of citizens of German extraction. During World War II, as we all know intimately here in Oregon, the forced relocation of American citizens of Japanese descent. During the beginning stages of the Cold War, the Smith Act prosecutions. With respect to the Japanese internment, Congress passed a law signed by President Reagan, not a knee-jerk liberal, apologizing for the civil liberties excesses of that time. Is the Constitution repealed in times of great danger? I don't think so. And in hindsight, our society, our country has come to the conclusion that in each of those prior instances, civil liberties violations were unjustified, that the government had gone too far after World War I and after World War II. Those Japanese exclusion cases are regarded, along with the Dred Scott decision, as probably the low point in Supreme Court history. Are we repeating the past? Have we learned anything? Will Americans 50 years from now look back on this time and say they handled it well?
Charles?
Well, I agree a lot with what Charlie had to say. Obviously, no system that is run by human beings is perfect, and we always have a job to do to make sure that we don't repeat mistakes of the past. I certainly know that everybody I work with is part of the consensus that rounding up Japanese American families and sending them to internment camps was a mistake. I notice that's not happening right now with Muslim families in the United States. Whatever you think of the current Bush administration, I think you have to concede that President Bush has gone out of his way to indicate that this is not a war against Islam or against Muslim Americans. So with regard to the Patriot Act, you know, the change in the wall, the tearing down of the wall between the intelligence community and criminal investigators is a big change. And I think when you hear our leaders talking about the importance of the Patriot Act, that's what they're talking about. The other areas, frankly, I think are minor changes that, as I mentioned before, update us to 21st century technology and communications. There may be some tinkering with that. There are a bunch of proposals in Congress to do one thing or another. One of the things I learned as an assistant U.S. attorney is we enforce the laws that Congress passes. And so I usually don't pay too much attention to the proposals because most of them end up not being enacted. When Congress enacts something, that's when I deal with it. But I don't think that people 25 years from now will say the Patriot Act was a mistake. I think, for example, Senator Feinstein, who's certainly no friend of the administration, was recently quoted as saying that she had asked the ACLU for examples of abuse under the Patriot Act, and she was provided with none. So I think that when people sit down and look at the actual provisions of the Act, they'll realize that it's not a dramatic infringement on civil liberties. Hope that answers your question.
Hi, I'm Hannah Kohlberg, Lincoln High School Constitution team. I have a question. Some of the sections deal only with terrorists, and I was wondering, what is a terrorist? What makes someone a terrorist?
You know, that's a really good question. And I have to say that the Federal Criminal Code does a lousy job of answering that question. The definition, and I'm going to have to paraphrase, but it goes something like this. The commission of a crime of violence in order to coerce or intimidate a civilian population or influence the conduct of government. And it goes on and on and on, and it's a real convoluted kind of deal. One of the changes in the Patriot Act, for example, and Mr. Hinkle was mentioning this, is that leaving aside this email issue, if we're investigating a case that involves international terrorism, we can now go to a judge in the district where the crime is being committed and get a warrant to search any place in the United States. And that's only true when it falls under this convoluted definition of terrorism. Now, I happen to think the Portland 7 case was a terrorism case. These were people who decided to go to Afghanistan and fight U.S. soldiers after 9/11. When we were getting ready to arrest the defendants, one of the places we wanted to search was the place where Muhammad Bilal was living in Detroit, Michigan, or Dearborn, Michigan. And if this was a terrorism case under the Patriot Act, I could have gotten a search warrant from a judge here in Portland to search that residence in Michigan. I took a look at the definition of terrorism, and I said, you know, it's so convoluted, I'm not going to take a chance. And we took our warrant request to a judge in Detroit and got a search warrant there. So the definition is kind of weird. What we really do when we prosecute people for crimes is we prosecute crimes that are in the federal code that would be committed by somebody who was a terrorist because it would allow them to achieve their political objectives through violence.
It's kind of tough. Jim Wittenberg, City Club member. In 1970 in Washington, D.C., I had a conversation with a gentleman in the White House named Jeffrey Donfeld. And we had some words, and we parted company as friends. Where he worked for the drug abuse group there in the White House. Within a matter of weeks, I found out that where I'd worked, where I'd lived, and associates of mine had been visited by the Secret Service. And my attorney called them and asked if we could come in and talk to them. They said they really didn't want to speak with me. They didn't have any reason to talk with me. When I got back to Portland 6 months later, they had also come to my brother's house over on Klickitat on 18th. And my brother told him to get the hell out of there and leave him alone, and literally threw them out of the house. When we went to the U.S. Attorney's office, we found a file this thick of papers on me as a, I don't know what the hell it was about, but that was, I was essentially a terrorist, I guess, at that time, or a threat to the person named Pat Nixon. And she was the only one in the White House I liked, you know? I'd never understood it. Okay, the question is, what stops you folks from doing whatever you want to do under the guise of this person was a terrorist because he had some argument with some person in the White House or down the thing? That went on 11 years as far as I know. In 1980, I was still being investigated by the Secret Service. Couldn't go to a presidential function.
Well, I'm not sure how I can answer the question. I wasn't here in 1970, and I don't know the specifics of this. The FBI receives tips, hints, calls, anonymous letters, people walking in the door, and they range from people that say that, you know, Attorney General Ashcroft is sending radio signals to my teeth, to people who have, you know, very serious allegations and credible evidence that back them up. Their job is to sort through that. And they do as good a job as they possibly can. The FBI has all kinds of rules, believe me, that tell them when they can open an investigation, how much evidence they have to have, how soon it's got to be concluded before the case is closed, and they try to follow those rules best they can. Those rules have been drafted over the years, in part in response to some of the problems that occurred in the 60s and 70s with the FBI. You know, I happen to have, somebody sent me a copy of a little one-page memo from J. Edgar Hoover to Robert Kennedy, Attorney General of the United States, saying, we believe that Martin Luther King is a communist and that he's communicating with communists, and we want authority to tap his telephones. And it's signed, approved, Robert Kennedy, Attorney General. That's all they had to do in 1961 to wiretap somebody. Now they've got to go see a federal judge. They've got to show probable cause that someone is committing a crime before they can wiretap someone. That couldn't happen today. The rules have changed over time, in part to protect our civil liberties. And the FBI does as good a job as any group of human beings can do in that. Remember, they are Americans too. They don't want to live in a fascist society, and they try to respect all of our individual liberties.
Would that it were so. I mean, those are beautiful words, and we'd all like to believe that everybody who's ever worked at the FBI has the highest of motives and carries their duties out with the utmost respect for civil liberties, but everybody in this room knows that isn't so, including Mr. Gorder. There are the instances of abuses and of the accumulation of information about innocent American citizens, the subpoenaing of bookstore records. That may not be done under the Patriot Act, but the government is going after bookstore records. It is going after college records of people who, and maybe they're the heart and soul of Al-Qaeda. I don't know, but to say that these things are not going on is, they may not be going under the particular provisions of the Patriot Act, which again raises the question, if that's so, why do we need the Patriot Act? I mean, if the government was able, using its powers of probable cause, to subpoena relevant records in the first place, why did we need this extra layer? And why is it that Senator Larry Craig of Idaho is worried about this, and why is he trying to repeal it? I mean, you talk about Dianne Feinstein, I'll keep giving you Larry Craig. You know, this is not a partisan issue. It is an issue for every American who believes that our civil liberties are being infringed. I mean, that list that I gave you of secret courts and secret detentions and closed proceedings and a refusal to divulge information and the infringement on attorney-client privilege, and most importantly maybe, well, I won't rank them. I mean, the extent the Patriot Act goes to consolidate power in the executive branch with no oversight by the judiciary. You know, a federal judge can no longer say, well, now wait a minute, what's your basis, Mr. or Ms. FBI agent, for wanting this court order to go get records from Sewanee University or Reed College? The judges are not permitted to inquire of the FBI agent what his or her reasons are, and they are not permitted to disclose these orders. I'm sort of at a handicap here because these things are all in secret. We have Attorney General Ashcroft's solemn assurance that there has been no subpoena to any library under the Patriot Act. Well, wonderful. How many subpoenas have there been under other provisions of federal law? You know, there's some librarians in the country now who have their monthly meetings with their boards of directors or their county commissions or something, and every week or every month they say, we didn't receive a subpoena this week. And in any meeting in which that statement is not made, then the government will know, or the board of directors will know, that a subpoena was received, because the librarian is not allowed to disclose the fact that he or she received one of these court orders to divulge information. I'm pleased that Attorney General Ashcroft says that there has been no use of it yet. Why does he want it renewed then?
My name is Maggie Larson, and I am a student at Lincoln High School. My question is related to the comments that Mr. Gorder was making in relation to connecting the dots. Connecting the dots between law enforcement seems like a reasonable issue. However, where's the connecting of the dots between the American public and the government? That seems really unreasonable, frankly, quite undemocratic. How do we, in our society, start to get the necessary information to decide whether these things are constitutional? I mean, we're all concerned citizens, and Mr. Hinkle was pointing out this is a issue that hits all of us. And I think that while there is misinformation about the Patriot Act, there's also a lot of misinformation going on about the war on Iraq, for example, and other issues related to terrorism. And that I was reading an article on something ridiculous, like 40% of Americans believe that Iraq was responsible for 9/11. There's been no proven connection between these two issues. How do we start getting information out to the public that is reliable, and how do we involve the people in making these decisions? Because really this is a issue that hits home for everyone.
Well, one of the ways we connect the dots between the American people and the government is, you know, come to forums like this. Try to educate yourself. as to what's going on. I will tell you that I was gratified after 9/11. The number of people who called the FBI unsolicited to report things, and they ran every one of those leads down. Now, a lot of them were phony baloney, but some of them led to the Portland 7 case, for example. And so I think that that is one of the ways that you can participate in this thing, is watching what's going on. I can't speak to what people think about the war in Iraq. I work for the Justice Department, and I want to stay out of political issues like that. But our society has to be vigilant. People like Mr. Hinkle keep me on my toes. And believe me, the federal judges here in Oregon keep us on our toes. You know, I can't just get on my phone and call up and say, hey, Judge Jones, could you get me an order to tap Charlie Hinkle's phones today? It's not going to happen. It doesn't work that way. There's a long, involved process to put together the paperwork to establish probable cause to tap someone's phone. It goes through any number of layers of bureaucratic approval, both here in Oregon and in Washington, D.C., before it goes to the federal judge. And these judges do keep us on our toes, believe me. And when someone gets prosecuted, then we have to justify the evidence is sufficient to prosecute them.
It's no secret that some federal judges are more sympathetic to FBI requests for subpoena power than others are. And one of the problems with this, with the Patriot Act, is that it allows the FBI to go judge shopping, to find the friendly judge in the Southern District of Wyoming or wherever he or she might be. And we won't know the data. We won't know the statistics, will we? Because it's all secret. The number of these subpoenas, to whom they are issued, where they are executed, we're not going to haven't been told any of that information. It's all kept secret, just like these hundreds of cases pending in the federal court involving these detainees. I mean, if it hadn't been for the mistake of that clerk in Miami, we wouldn't even know about the Arab waiter, Algerian waiter, who was detained on charges of violating his student visa. The cloak of secrecy that the Bush administration is placing around these things is one of the most frightening things about it. And the misinformation, not just from the editorial page of the Oregonian, but from the Department of Justice, from the spokespersons for the U.S. Department of Justice about the Patriot Act. And Charles, I'll give you this paper about all the misinformation that the Justice Department has put out about Section 215 of the Act, the one that allows the library subpoenas and so forth, is just amazing. Stay informed.
Well, I'll be happy to take a look at your paper, but since there haven't been any of these library subpoenas under 215, I'm not sure there could be a lot of misinformation about it. I will say one other thing about secret courts. You know, every time we get a search warrant to search someone's property, it's a secret. We don't tell the criminal ahead of time that we're coming to find evidence of a crime. It's done in secret. But it doesn't mean that a judge who does not work for the FBI or John Ashcroft doesn't exercise independent judgment. Believe me, I've been there. They ask tough questions. They go through the material that we provide them before they sign any warrant for the search anyone's house or anything else.
I think we have time for one question over here and one question over here, and then we'll be...
Tom Welch, City Club member. I must admit to being more confused than when I got here today. It sounds like you two gentlemen are discussing totally different acts or issues, and I must say I'm a bit confused. Mr. Gorder, as an Oregonian, I am heartened, though, by one of the messages you bring us in the subtext of your talk is that jobs are being created by the Bush administration. Of course, no right to collective bargaining, lousy pay and benefits, but jobs nonetheless. My question to you, sir, at last count, over 200 municipalities across the United States of all sizes have passed resolutions indicating dissatisfaction with the Patriot Act, mandating noncompliance, among other things, at various points. What do you suppose they know that you don't?
Well, they are low-paying jobs too, but very rewarding jobs. So again, I would encourage anybody who wants to do the right thing to consider it as a career. Most of the resolutions that I have actually read that various local municipalities have passed have frankly been a part of the misinformation that I think is out there about the Patriot Act. They quote provisions of the Patriot Act that don't exist, and I'm sorry that our questioner is still confused. I frankly don't think the Justice Department has done a good job of explaining to the public the provisions of the Patriot Act and what we're doing. That's why I'm happy to be invited to forums like this one, where we can try to explain that. Apparently, at least for some members of the audience, I haven't done a good enough job on that. And I'll be up here after the cameras go off if you want to ask any more questions. But there is incredible misinformation. I would like the opportunity to sit down with Senator Craig and go over his concerns, because I think if I could, I would convince them that we don't need to make major changes in the Patriot Act.
Do judges have any independent role? Listen to the words of the law. Upon an application made pursuant to this section, the judge shall enter an order approving the release of records if the judge finds that the application meets the requirements of this section. And you know what the requirements of this section are? Simply that the FBI agent says, I certify to you, judge, that this is relevant to an investigation. The judge has no power to inquire behind that. Secondly, and the last point I make is, Mr. Gorder keeps focusing on the Patriot Act as though that were in isolation. You cannot view it in isolation. He said at the beginning there's been no abuse of Arab citizens. The United States the Inspector General of the United States Department of Justice, who is also Mr. Gorder's employer, issued a report in the last few weeks documenting the physical abuse of the 82 Arab Americans detained after 9/11, not under the Patriot Act, detained under immigration laws, the physical abuse that they were subjected to in the federal prison in Brooklyn, New York. You know, it's well and good for Mr. Gorder to say there's been no abuse of Arab citizens under the Patriot Act. Wonderful. How about the abuses of Arab American citizens detained under this other provision of the law?
We're past our normal time for closing.